I know, but I just felt like
Mr. Walker, let me just say this. Your first mistake was confusing my youthfulness for softness. Your second mistake was thinking. So this is what I'm thinking. I believe that our strongest argument for trial purposes is a breach of good faith, a good faith covenant. It's right there, clear as day in the contract. I went through it, and that to me is our slam dunk. Yeah. What do you think?
No, I agree.
I mean, obviously, you may have other.
My thing is, because I thought about, you know what I'm saying, the conversation we had, you know what I'm saying, when Natasha was on the case, I'm like, okay, we kind of should play into the racism. Because the lady is racist.
That's true, and I'm not saying that we won't use those incidents of harassment and racism as to support, but we're going to use it for the purposes of proving that it was a breach of good faith behavior from her as a landlord to you as a tenant. Does that make sense? There's a little nuance there, because we're not arguing she's racist and this is harassment. We're saying she's doing harassing and racist things, but because we can't prove a prima facie case for that, we're going to have to go from the breach of contract angle here.
But, okay.
Which we got a better chance
of winning at trial.
I understand that, but y'all said we got a black judge, right?
Correct.
We got a black judge, and you mean to tell me we're not going?
That's not how this works. The judge is not the one who's weighing the evidence. Right. It's the jury. And we cannot guarantee an all-black jury. We can't guarantee. I mean, hell, even the landlord married to a black man.
Right.
So, I mean...
But that don't mean nothing. What does that mean? Just because you're married to a black man?
Could we not say the same thing about what you're saying right now? That doesn't mean anything. That's what we're trying to tell you. Like, we don't know. We're going to do our best to choose a favorable jury, but still... We can't guarantee. You never can guarantee anything in the law.
No, what I'm saying is we got a black judge. I'm a black man. This white woman who's a landlord who feels like she's over me is being racist. All the stuff that's happening in this world. We got this president doing racist stuff. We got cops killing kids. The father of that kid is killing the cop.
And you're confusing a civil rights case with a breach of contract case.
Yeah.
I'm not saying that the experiences that you've had with her are not valid and will not be brought up at trial. I'm saying in order for us to win in front of a jury, we have to bear the burden of proof, which means that we have to meet a prima facie case, and that is element-based, rooted in statute, rooted in law, not our feelings. Because in Georgia, there is no remedy or recovery for hurt feelings. Right. That is exactly what. So we have to play this from an angle in which we can win, and that's breach of contract.
$75,000. That's the least we ask. For you to be racist to me, I want $75,000. All these cases where people are suing for racism and all these wrongful convictions and all this, you don't think we could? I don't.
They probably have proof.
Let me ask you this: you're saying $75,000. Do you want to win or not?
Of course, I want to win.
Okay, so I need you to get serious, because if you don't, you're going to lose. Yeah. Because I'm telling you, there is no way in the world that you're going to win at trial just arguing they racist, they racist, they racist. You need something that is rooted in the law. Okay? Like, period. There is no escaping that at trial.
I feel like you, just because she's new to the case and this is what her approach to it is like, it don't really. I mean, I get it, man.
But it's my same approach. Remember, I told you about that.
I know, but I just felt like
Mr. Walker, let me just say this. Your first mistake was confusing my youthfulness for softness. Your second mistake was thinking because I'm youthful that I won't put you in your place. I was invited on this case for a reason. And I'm telling you, if we go into that courtroom and argue race, we are going to lose, because there is no recovery for you. This is a breach of contract case, period. We need to argue constructive eviction. We're going to have to get creative for that. This might be a case that may even go up on appeal, but we cannot go in there just screaming the race card thinking we're going to get a result. So if you want $75K, the way to do it is breach of contract, because the language in your lease agreement supports that. Now, if you don't want to do that, then you go right ahead and I can leave right now. But I was brought here to get you a win. Okay? I'm a winner, not a loser. And right now, you're thinking like a loser.
Boom. All right. Whatever y'all say, man.
Please.
Whatever y'all say.
Thank you.
I'm telling you, we got you.
I got you guys food over here.
Thank you.
Bianca, eat something?
I'm good.
Yeah. Chase might need Snickers or something.